Hey y'all, what's good? Welcome to another episode of the Legislative Corner. Today, there's a piece of legislation that is being pushed through from 2019 um, for inclusion and equality, and we're gonna get into that here in just a minute. Again, I appreciate y'all coming through and listening to what I gotta say about this piece of legislation, and give you the breakdown, an actual piece of legislation, and let you decide if you want to support it or etc. And by no means this is, you guys know I'm not a lawyer, but I will give you my opinions on this legislation, because it's important. It's going to affect our daily lives from the federal level, right? So, without further ado, let's go ahead and let's slide into that real quick here. So, what we have is the HR 2574, the Equity and Inclusion Enforcement Act of 2019, which was introduced by Robert Scott out of Virginia. And it passed out of the Judiciary, Education, and Labor Committee and the Senate Health, Education, Labor, Pensions Committee also, and it did pass the House, and we'll get into the voting portion of this in just a moment. So let's just get over to the bill real quick. Let's read what the bill says, and any other stuff that kind of goes with it here. So we have the bill here, HR 2574, an act to amend Title VI of the Civil Rights Act of 1964 to restore the right to individual civil actions in cases involving disparate impact and for other purposes, be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled. Section 1, short title, this act may be cited as a Equity and Inclusion Enforcement Act of 2019. Section 2, restoration of right to civil action in disparate impact cases under Title VI of the Civil Rights Act of 1964. Make that a little bigger for you guys so you guys can actually see this. Try to fill the screen with it a little bit so it'll be a little better so you can see that there. So Title VI of the Civil Rights Act of 1964, United States Code 42, Section 2000D, is amended by adding at the end of the following: Section 607, the violation of any regulation relating to disparate impact issued under Section 602 shall give rise to a private civil cause of action for its enforcement to the same extent as it does an intentional violation of the prohibition of Section 601. So let's take a look here real quick. Let's look at Title VI of the Civil Rights Act of 1964. Let me blow that up for you guys so you can see that. All right. So we see the Section 2000D, prohibition against exclusion from participation in denial of benefits and discrimination under federally assisted programs on grounds of race, color, or national origin. No person in the United States on the ground of race, color, or national origin be excluded from participation and be denied the benefits of or be subjected to discrimination under any program or activity receiving federal financial assistance. Now, if we go back over here, where we're at, Section 601. If we look at Section 601, this doesn't define it too well. This is kind of the Department of Labor's site and version of it. But 601 basically is theoretically saying the same thing, right? So Section 3, designation of monitors under Title VI of the Civil Rights Act of 1964. Title VI of the Civil Rights Act of 64 is further amended by adding at the end the following: Section 608, each recipient shall designate at least one employee to coordinate its efforts to comply with requirements adopted pursuant to Section 602 and carry out the responsibilities of the recipient under this title, including any investigation of any complaint alleging the non-compliance of the recipient with such requirements and alleging any actions prohibited under this title, and 2, notify its students and employees of the name, office address, and telephone number of each employee designated under paragraph 1, which is the paragraph up above there. in this section, the term recipient means a recipient referred to in Section 602 that operates an education program or activity receiving federal financial assistance authorized or extended by the Secretary of Education. C, anti-Semitism considered discrimination. In carrying out the responsibilities of the recipient under this title, the employee or employees designated under the section shall consider anti-Semitism to be discrimination on the basis of race, color, or national origin as prohibited by this title. Section 4, Special Assistant for Equity and Inclusion. Section 202B of the Department of Education Organization Act is amended by redesignating paragraph 4 as paragraph 5 by inserting after paragraph 3 the following. There shall be in the department a special assistant for equity and inclusion who shall be appointed by the secretary. The special assistant shall promote, coordinate, and evaluate efforts to engender program compliance with Title VI with the Civil Rights Act of 1964 and inform individuals of their rights under such act, including the dissemination of information, technical assistance, coordination of research activities in a manner consistent with such act. The special assistant shall advise both the secretary and deputy secretary on matters relating to compliance with Title VI of the Civil Rights Act of 1964. So that narrows it, pretty much narrows it down to, you know, where it needs to be. This bill is literally an expansion of government, right? They're creating another person, or theoretically, they're creating another department within the Department of Education to enforce this. When, you know, we do have overseers in all of our alphabet branches, like the IG, right, that can oversee these things, etc. I mean, to have someone directly appointed to that position, you know, that's almost $150,000, $200,000 a year position that they're setting up for someone, right? So the more of our text dollars is going into more federal oversight, more federal overreach, you know, than necessary, right? We'll just they just want to keep expanding government. So I want to go over, and here's the vote tally. Here's the vote tally on that. I'll go ahead and get that expanded for you guys here. The votes basically went down party lines. As you can see, 229 Democrats voted yes. None of them voted nay. 2 of them didn't vote. 3 Republicans joined the Democrats on this bill, while 187 said nay, and the independent also said nay. Now, the Republicans that did join the Democrats in this endeavor was Representative Bacon out of Nebraska, Representative Fitzpatrick out of Pennsylvania, and Representative Katko out of New York. These are your guys that actually got voted for the bill to pass through to the Senate. Okay, and these are the proxy votes, and we know how that goes, but you can view that for yourself. I'll put the link in the description so you can link up and see who voted by proxy for whatever representatives were not there in Congress at the time. So that's the bill. I will say that I'm just going to give you my flat out full-fledged opinion about this bill. This bill is going to amend the Civil Rights Act of 1964 to create a private right of action to file disparate impact claims, as we read, right? The disparate impact refers to discriminatory effects caused by policies that on their face appear neutral as instituted by an organization or employer. I've been reading, according to some legal experts that has weighed in on this, and the analysis of court filings and data from the federal judiciary over the past 30, 40 years or so on, disparate impact claims brought under Title VI were more often related to education, although they're applicable to housing, public transportation, and other things, right? That have, supposed to have be equitable when you're handing out federal stuff, right? Um, and that they have historically constituted a small portion of civil rights litigation. Most of the claims are filed under other titles of the act regarding employment issues. Right now, using the information from the experts I have from civil law, it's expected that the enactment of this bill could result in a small increase in the number of suits filed in federal court related to disparate impact cases under Title VI. Now, the federal judiciary charges fees to file suit in district court. Those fees are recorded as revenues and can be spent by the judiciary without further appropriation or action, because the expected increase in the number of lawsuits is small. I tend to think that enacting this bill would increase both direct spending and revenues by insignificant amount over probably a 10 15 year period. Now, I will also add that this bill, this HR 2574, would require recipients of federal aid from the Department of Education that operates educational programs or activities to establish at least one employee coordinator to carry out those recipient responsibilities under Title VI, as we read in the bill, which includes investigating complaints of discrimination based on race, color, national origin, creed, things like that. The bill would also require that the Department of Education to appoint a special assistant to their Department for Equity and Inclusion to promote the coordination and evaluation of equity and inclusion programs and education. Now, I was looking at the CBO, and they estimate that implementing the required cost, implementing the requirement would cost over $1 million over a 5-year period, right? So you're thinking, maximum salary for this individual could easily be $200,000 a year, as I was mentioning before, right? So, we're adding money into this budget for God knows what reason, just to make sure everybody's compliant with, being equal, etc. Now, am I a fan of that? Not really. Yeah, I'm not. I'm not a fan of Like I said, we have the IG for oversight, in our alphabet agencies that can do this job exactly, right? I mean, that's their purpose, to make sure, federal institutions that are attached to, the main institution, like the Department of Education or FBI, et cetera, are also complying with federal regulations. So I don't know why they would want to create this position, but it is what it is, and we kind of need to have them strike that out of the record, and continue to bloat our government. At least we have to contact the Senate at this point, because it's already passed the House. I will say too, looking at this, I was looking at the CBO, and they haven't reviewed this yet for intergovernmental or private sector mandates. And Section 4 of UMRA, if you're not familiar with UMRA is the Unfunded Mandates Reform Act. And it excludes from the application of that any act, any legislative provisions that would establish or enforce statutory rights prohibiting discrimination. So, and they did determine that this legislation falls within that exclusion because it would extend protection against discrimination in education on the basis of race and national origin. So that's all I have for you guys. I appreciate you again, checking me out here, etc. If you have, you have some comments on this, etc., please drop them down below down there and let me know what you think. Maybe is there something we could amend? We could put something together to send to our senators, email or a phone call or something, to have them strike something out of there, or potentially have something added to it. And that would be great. Let's coordinate on that. Those of you that are probably watching this right now probably are on the Slack channel. So definitely leave the information in the Slack channel for me. Or for everybody to see, let's have a discussion about it. Right. So, again, I appreciate you guys, coming through and listening to, this, me break down this piece of legislation and what it means. And until next time, y'all, I appreciate you, and we'll see y'all again on another, video on the Legislative Corner.